Hello, I'm Judge Thomas Mulvihill with the 20th Judicial District. I'd like to talk to you about the prosecution's obligation to provide discovery to a defendant in a criminal case. Pretrial discovery in a criminal case is dictated and regulated by Rule 16 of the Colorado Rules of Criminal Procedure, as well as constitutional due process requirements. Rule 16 is self-executing, and the prosecution's obligation to provide discovery to the defense is automatic, and it does not require a motion or request by the defense. Discovery of relevant information should occur well in advance of trial and without the need for involvement by the court. Rule 16 requires the prosecution to provide the defense with certain specified information automatically and as soon as practicable. The prosecution must always disclose any information in their possession or control which tends to negate the guilt of the defendant or would tend to reduce the punishment. The prosecution's duty of disclosure extends to all material and information in the possession or control of his staff and any other investigators who have reported to the prosecution. The prosecution also has a duty to ensure that the flow of information is maintained between investigating officers and the prosecution's office so that all relevant material and information is placed within their possession and control. In the event that you find that there has been a discovery violation, you will need to consider the appropriate sanction to impose. The choice of an appropriate sanction for a violation of discovery rules lies within the sound discretion of the trial court. However, that discretion is not unlimited. The trial court must be cautious not to affect the evidence to be introduced at trial or the merits of the case more than is necessary. Absent willful misconduct or a pattern of neglect demonstrating a need for modification of a party's discovery practices, the trial court should use sanctions only as a means to cure the prejudice resulting from the discovery violation. When you're considering sanctions for a discovery violation, you should look at the reasons that the disclosure was not made, the extent of the prejudice, if any, to the opposing party, the feasibility of rectifying that prejudice by a continuance, and any other relevant circumstances. A trial court should impose the least severe sanction that will adequately remedy the violation. If you are considering the exclusion of evidence as a sanction, be aware that appellate courts have recommended that trial courts avoid excluding evidence because the attendant windfall to the party against whom the evidence would have been offered defeats rather than furthers the objectives of discovery. Exclusion of evidence is a drastic remedy and therefore is strongly disfavored, especially since, in many cases, it may well determine the outcome of the trial. If you are considering dismissal of charges or the case in its entirety as a sanction for a discovery violation, be aware that dismissal is a drastic sanction and must be reserved for situations where no other sanction will restore as near as possible the level playing field that existed before the discovery violation. In the absence of willful misconduct, dismissal as a sanction for a discovery violation is usually beyond the discretion of the trial court.